New York. Driving without a license. Lawyer, criminal defense attorney. What is considered unlicensed operation of a motor vehicle? A person is guilty if he or she operates or drives a motor vehicle upon any sidewalk or to or from any lot adjacent to a public garage, supermarket, shopping center, or car washing establishment and is unlicensed. A motor vehicle as defined by this statute means every vehicle operated or driven upon a public highway which is propelled by any power other than muscular power. To be found guilty of the crime of unlicensed operation of a motor vehicle, the prosecution must be able to prove beyond a reasonable doubt two elements. 1. That on the date alleged, the defendant operated or drove a motor vehicle upon a public highway, sidewalk, or to or from any lot adjacent to a public garage, supermarket, shopping center, or car washing establishment, and 2. That the defendant did so without being duly licensed. Under New York state law, a person is guilty of aggravated unlicensed operation of a motor vehicle in the third degree when he or she operates a motor vehicle upon a public highway while knowing or having reason to know that his or her license has been suspended, revoked, or otherwise withdrawn by the Commissioner. A person operates a motor vehicle by driving it or when he or she is sitting behind the wheel of a motor vehicle for the purpose of placing the vehicle in motion. A person may be considered to be operating a vehicle even if the vehicle is not moving but the engine is running. Under New York state law, a person is guilty of aggravated unlicensed operation of a motor vehicle in the second degree when a person operates a motor vehicle upon a public highway while knowing or having reason to know that his or her license has been suspended, revoked, or otherwise withdrawn by the Commissioner. Additionally, the person has previously been convicted of an offense that consists of or includes the elements comprising the offense committed within the immediately preceding 18 months. A person is also guilty if the suspension or revocation was based upon one of the following. 1. A refusal to submit to a chemical test. 2. A DWI. Or, 3. A conviction for a violation of any provisions of Section 1192 of the Vehicle and Traffic Law. Under New York state law, a person is guilty of aggravated unlicensed operation of a motor vehicle in the first degree when a person is operating a motor vehicle while knowing or having reason to know that his license or privilege of operating a motor vehicle in this state or privilege of obtaining a license to operate a motor vehicle is suspended. Additionally, the person will be found guilty if he or she has in effect 10 or more suspensions, imposed on at least 10 separate dates for failure to answer, failure to appear, or failure to pay a fine in connection with an administrative or judicial proceeding. Call Lebedin Kofman LLP today at 646-663-4430 or contact us online to set up a free initial case evaluation with our Driving Without a License lawyers in New York.